I thank the gentleman for yielding. Mr. Dettelbach, the pistol brace is an accessory, right?
Alone,
firearms.
without attached to anything, the pistol brace is not something that we regulate.
But when it's attached to pistol, it can become a short-barreled rifle, and then it's subject under the National Firearms Act. That's what you're saying.
Depending on the features of both the pistol and the brace. And there are some, the forearm, everybody talks about forearm braces. True forearm braces that are not designed and intended to be shouldered would be classified and not covered.
And the bump stock's an accessory, right?
The bump stock is a conversion device, I believe. So I want to check. Our position on that is in briefs, but that's a different provision of the Act. That's a provision.
The bump stock gets added to a firearm, and that's now subject to the NFA. And
so the NFA specifically says that items which can be used to convert something to a fully automatic weapon are covered by the NFA. So those are the words Congress used. They didn't use the word accessory. They used things that.
And you guys said the bump stock fits that definition and is subject to the NFA, right?
Correct. The bump stock then
that's been challenged in court, right?
It's currently before the courts. There's a split in the different courts.
Splits in the courts. I'm just looking at the one that came out yesterday. Sixth Circuit, one you're familiar with. Sixth Circuit.
Right. The Sixth Circuit, I think, ruled yesterday. A panel of the Sixth Circuit. There's a prior en banc, and I haven't had a chance to review
Let me read and just tell me if you think. Here's what the court said. The viability of competing interpretations is exemplified not only by the myriad and conflicting judicial opinions on the issue, but also by the ATF's own flip-flop in its position. And that's what I think concerns Americans. Is you guys told us all one thing, told the country one thing on the bump stock, and then you change. You told the country all one thing on pistol braces, and then you change. And that's the conflict. And on this situation, bump stocks, I don't know how many Americans had that, but my guess is not near as many have had the brace. Now we're talking about a situation that I doubt you've ever been in before, where you're going to make a rule that's going to impact millions and millions of Americans. And that's the problem. That's the concern. That's why you're here talking to us today. Lots of Americans have, that's why there are cases all over the country, because you said one thing and you flip-flop. Not my words, the Sixth Circuit, their words. That's the problem.
Of course, I understand the legal record, and I haven't read the opinion, and I will. With respect to what happened in the prior administration when that rule was issued, of course, I wasn't there and don't know the details, but our legal position is spelled out publicly as to what the rule that was issued in the prior administration said.
I'll yield back to you. You're the chairman. Your function is chairman. I'll yield back to you to close it out.
That concludes the hearing for today. We thank our